Good morning. I'm Elaine Gagliardi, and it's my privilege to serve as Dean of the Alexander Blewett III School of Law. Before I begin, I want to read the land acknowledgement. This law school and the wider university is on the traditional lands of indigenous peoples, including the Salish, Kasanka, and Kudlespi. Many others, including Blackfeet, Nez Perce, Shoshone, Bannock, and Coeur d'Alene, had and continue to have a crucial presence in the area. We acknowledge the role the legal system has played in the removal of indigenous peoples from these lands, and through our commitment to education, service, and scholarship, strive to improve the quality of justice for future generations. Doing so demands respect for tribal sovereignty and indigenous cultures, as well as accountability to the needs and perspectives of indigenous peoples, who from time immemorial to the present and until the end of time protect and remain connected with this land on which we gather, live, learn, and work. I want to start by thanking all of you for being here, and especially the high school students who are here. I'm so glad to see that you were able to come. And thank you to all our law students who are here, because I see so many that are not familiar with the day-to-day workings of the school. I just want to take a few minutes to tell you about our school. Montana's law school is a school that prides itself on training lawyers for the people-oriented practice of law, for representing individuals and their needs, and for solving their problems. And we have a wonderful law school. We have strong outcomes. If you compare ourselves to our peer schools, we are first in our two-year bar passage rate at 97.5%. We have over a 96% employment rate. Princeton Review ranks us as a top 10 school nationally for prestigious state clerkships. And I am also proud to be able to say that 6 of the 7 justices of our Montana Supreme Court graduated from this law school. 2 of them were actually my classmates. In addition to it being an honor to serve as dean of our law school, it's an equal honor for me to have been able to serve as a lawyer and represent Montanans in solving their legal needs. Today, I am so glad you are all here to see our legal system at work. My brief remarks are going to focus on the role of lawyers and our judiciary in protecting individuals and the rights afforded each of us by the state and federal constitutions. The Montana Supreme Court is one of 3 branches of government, and like the legislature and the executive branch, in Montana, our Supreme Court justices and other judges are elected by the people. Each branch provides a check and balance of the other 2. The legislature enacts laws based on the will of a majority of the people. The purpose of the Montana Supreme Court and the courts is different. It is to protect not the will of the majority, but to protect the constitutional rights of each individual person. It provides a forum where persons can resolve disputes in a civil manner that affords due process of law. And that is what you will be observing here today. Lawyers have the privilege and honor of helping individuals assert their rights and arrive at a peaceable and just solution. The justices of the Montana Supreme Court protect and preserve for us individual rights granted under the law and the Montana Constitution. The independence of the court system is the cornerstone of our democracy. And with that, I want to invite our law student, Ms. Addie Slanger. She is a second-year law student, incoming editor-in-chief, and former editor-in-chief of the Montana Law Review, and she was a former editor of the Kaiman, which is the University of Montana's newspaper. Ms. Slanger is going to introduce the case that is before the Montana Supreme Court today. She will explain the procedural posture of the case and provide an overview of the arguments that you might hear. Please join me in welcoming Ms. Addie Slanger.
Thank you, Dean Gagliardi. Good morning and welcome, everyone. My name is Addie Slanger, and I'm a second-year law student at the University of Montana's Alexander Blewett III School of Law. On behalf of the Montana Law Review, I would like to thank the Montana Supreme Court for traveling to Missoula to hold this oral argument and for giving me this opportunity to introduce the case before the court today. We are here today for oral argument in State of Montana versus Andrew John Smith. Mr. Smith was convicted of deliberate homicide. He is appealing that conviction. I'm going to tell you the facts of the case. Then I'll explain what happened at trial. Finally, I'll explain the issues on appeal and preview what you're likely to hear today. On the evening of July 15th, 2021, Mr. Smith stepped outside of his apartment in Winnett, Montana, a small town north of Billings. Mr. Smith went outside to smoke a cigarette in the courtyard area of his apartment complex. At the same time that Mr. Smith stepped outside to smoke, Larry Patterson was in the courtyard. Mr. Patterson lived in the same apartment complex. The two men did not know each other well. Before this evening, the two had only limited interactions. We know Mr. Smith had a pocket knife on him. Mr. Patterson had a pistol in his pocket. Kimber Sandman, Mr. Smith's fiancée, was inside the apartment she shared with Mr. Smith. She said that soon after Mr. Smith left the apartment, she heard popping or banging noises that sounded like a screen door shutting hard. Miss Sandman went outside to see what was going on. In the courtyard, she saw Mr. Patterson near the front of his apartment. He was holding his arms close to his body. She saw blood coming from his torso. She also saw Mr. Smith. He had blood coming from a wound on his arm. At this point, Miss Sandman called 911. The operator told her to apply pressure to Mr. Patterson's wounds. Miss Sandman explained that Mr. Patterson was not responding. He had no pulse. Mr. Patterson died from the stab wounds. The forensics showed that Mr. Patterson was stabbed 8 times. They also show that Mr. Smith was shot. The bullet grazed his upper left arm and chest area, and he recovered from his injury. There were no witnesses to the altercation. Mr. Smith was charged with the deliberate homicide of Mr. Patterson. At trial, Mr. Smith's case was built around self-defense. Mr. Smith said he acted in self-defense to protect himself from getting shot. His story is that he approached Mr. Patterson to ask him for a light. When Mr. Patterson did not respond, Mr. Smith became irritated. A verbal argument ensued. Mr. Smith alleges Mr. Patterson pulled out his pistol. He says he told Mr. Patterson to put the gun down and back away, but Mr. Smith says Mr. Patterson shot him. Mr. Smith said he then snapped and stabbed Mr. Patterson defensively. The state argued that Mr. Smith was the aggressor. The state pointed to contradictions in Mr. Smith's story. Prosecutors explained that investigators found Mr. Patterson's blood on the inside of his pocket, suggesting Mr. Patterson was already bleeding before he reached for the gun. Ultimately, the jury convicted Mr. Smith of deliberate homicide. Before the trial took place, Mr. Smith made it clear he wanted to introduce evidence of his past mental health issues. Specifically, Mr. Smith wanted to introduce evidence of his struggles with delusions. You might hear the parties refer to this kind of evidence as mental disease or defect evidence, or MDD evidence. Mr. Smith wanted to argue that his delusional thought process made him act under extreme stress when he stabbed Mr. Patterson. Under the law, if you act under that extreme stress, it can reduce the severity of the crime, in turn reducing the sentence. The district court did not allow Mr. Smith to introduce evidence of this delusional thought process. Mr. Smith is appealing the court's decision to exclude this evidence. To understand why this matters, it is helpful to know some basic principles of criminal law. In a criminal case, the parties are the government, here the state of Montana, and the accused person, here Mr. Smith. The government is referred to as the prosecution, and the accused person is referred to as the defendant. The prosecution has to prove the criminal case. For deliberate homicide, the state must specifically prove that Mr. Smith intended to commit the act that killed Mr. Patterson. In criminal cases, even if the state proves that a defendant committed the act, the defendant might be able to avoid the conviction if the defendant has what's called an affirmative defense. An affirmative defense is like a justification or an excuse for a defendant's actions. In relying on an affirmative defense, the defendant is essentially saying, yes, I did this illegal act, but there is a reason why I shouldn't be held responsible. If a defendant is successful in claiming an affirmative defense, he will be acquitted, which means found not guilty. In addition to affirmative defenses, a defendant could argue the jury should consider convicting him of what's called a lesser included offense. A lesser included offense is essentially an argument that a defendant should be convicted of a less severe crime. In this case, there's a specific affirmative defense Mr. Smith raised. That defense is called justifiable use of force, more commonly thought of as self-defense. There is also a specific lesser charge Mr. Smith wanted to have the jury consider. That lesser charge is called mitigated deliberate homicide. Mr. Smith wanted to make what is called an alternative argument. If the jury didn't believe Mr. Smith's self-defense argument, Mr. Smith wanted the jury to consider the lesser crime of mitigated deliberate homicide as an alternative. Mitigated deliberate homicide means the defendant intended to commit an act causing the death of another, but did so under the weight of extreme mental or emotional stress. Mr. Smith wanted the jury to hear evidence of his delusional thought process to support that he was acting under extreme mental stress. He wanted to argue that if he wasn't acquitted based on self-defense, he should be convicted of the less severe crime. Mr. Smith was not able to make this argument at trial. Before his trial began, as you heard, the district court ruled Mr. Smith could not introduce evidence of his delusions. Because the district court prevented Mr. Smith from introducing this evidence, he was not able to make the alternative argument for the lesser charge. Mr. Smith is appealing the court's decision to exclude this evidence. That leads me to explain an important part about how a jury trial works. In a jury trial, the judge and the jury have different jobs. It's the judge's job to say what the law is. The jury's job is to hear the testimony, examine the evidence, and determine the facts. In a criminal case like this, the judge gives the jury instructions on what the law is and then asks the jury to find the facts and apply the law. A defendant is entitled to jury instructions on every issue or theory that is supported by the evidence. A judge must give the jury an instruction on a lesser charge when the evidence supports that lesser charge. But the inverse is also true. When no evidence supports a lesser charge, the court does not need to instruct the jury on that lesser charge. There is a question under Montana law about whether a defendant can be entitled to a jury instruction on a lesser charge while also seeking a not guilty verdict through an affirmative defense. Specifically, the dispute in this case is whether Mr. Smith could have faced the lesser charge of mitigated deliberate homicide if he also brought justifiable use of force as a defense. In this case, the district court did not instruct the jury on the lesser crime of mitigated deliberate homicide. Mr. Smith is arguing that he should have been allowed to bring both a justifiable use of force defense and to introduce evidence of his mental condition to receive a lesser charge instruction. Mr. Smith will likely make technical arguments about why he should have been allowed to use these alternative theories before the jury. Mr. Smith may try to distinguish his case from other cases. Those other cases are the ones that say if a defendant brings an affirmative acquittal defense, a lesser charge instruction is not supported by the evidence. As you recall, if no evidence supports a jury instruction, the court does not need to give that jury instruction. So essentially, these other cases say a defendant cannot get a jury instruction on a lesser charge if the defendant brings an affirmative acquittal defense. Mr. Smith may argue that a rule always prohibiting a lesser charge instruction if a defendant has an acquittal defense is inappropriate. He may argue the rule does not prohibit a lesser charge instruction in his case. The state will likely respond by arguing that the district court made the correct decision. It may argue that the district court properly determined Mr. Smith was not owed the lesser charge jury instruction because he chose to bring justifiable use of force as a defense. You may also hear the parties argue about the more basic question of whether evidence of Mr. Smith's delusional thought process could even have been used to show evidence of extreme mental or emotional stress in the first place. Mr. Smith may argue that evidence of his mental condition should be allowed to support the idea that he acted under severe stress at the time of the incident. The state may argue that evidence of Mr. Smith's delusions cannot actually form the basis for acting under extreme mental or emotional stress. The state may argue that a defendant needs to show emotional turmoil coming from some external trigger to demonstrate he was acting under the extreme stress required by mitigated deliberate homicide. The classic form of mitigated deliberate homicide is one person killing another because of something that the victim did to the killer. Take the following example. Person A kills person B's dog. In the heat of the moment, person B kills person A. The state charges person B with deliberate homicide. Person B could argue he should be convicted of the lesser crime, mitigated deliberate homicide. Person B could claim he was acting under extreme stress because person A had just killed his dog. This is an example of an external trigger. In contrast, the state may try to argue that evidence of Mr. Smith's delusional thought process comes from the internal source of Mr. Smith's own mind. Therefore, the state may argue it cannot be used to support the lesser charge. There's another possible issue you may hear about today. During trial, and before the jury had begun deliberation, the court received 2 questions from jurors. Both questions were about evidence in the case. The judge instructed the bailiff to tell the jurors he could not answer their questions. Afterward, the judge let the state and Mr. Smith know about the questions and his response. Mr. Smith is challenging the court's decision to respond to the jurors without first consulting the parties. This leads us to today. We are here for an oral argument before the Montana Supreme Court, the highest court of appeals for issues involving Montana criminal law. Oral argument is different from a trial, where the parties call witnesses, present evidence, and develop the factual story of the case in front of a judge and a jury. In contrast, oral argument is more like a conversation between the lawyers and the justices of the court, each of whom have already reviewed the record from the court below and the briefs of the parties arguing. At oral argument, lawyers will focus on the issues they believe the trial court got wrong. The justices will ask the parties questions to better understand their arguments. The party who brings an appeal because they lost at the trial court is called the appellant. Mr. Smith is the appellant. The party who won at the trial court is called the appellee. Here, the state of Montana is the appellee. In this oral argument, you will first hear from Colin Stevens, the attorney for Mr. Smith. Then, you will hear from Roy Brown, representing the state of Montana. After today, the court will take the arguments under advisement. The justices will deliberate and discuss the issues in the coming weeks and months. Then, they will provide their final written decision. Once more, I would like to thank the Montana Supreme Court for the opportunity to present this case on behalf of the Montana Law Review. And thank you all for joining us. I look forward to hearing this oral argument. Thank you.
All rise and give your attention. The Honorable Justices of the Montana Supreme Court. This court is now in session.
Morning, everyone. We are glad to be here at the University of Montana. This is State of Montana versus Andrew John Smith, cause number DA 22-0484. This is a time designated for oral argument. Before we begin, I would invite counsel to just introduce yourselves and whoever's at your table, and then I'm going to introduce the members of the court.
Good morning, Your Honors. Colin Stevens, representing the appellate.
Morning, Your Honors. Roy Brown, representing the state. Assistant Attorney General Thorin Geist at counsel table.
So I'm going to briefly introduce for all of you the members of the court. Starting at the far left end of the table is Justice Jim Rice. Next to him is Justice Jeremiah Shea. And then immediately next to me is Justice Lori McKinnon. And to my right is Justice Ingrid Gustafson. And next to her is Justice Beth Baker. And then on the far end of the table is Justice Catherine Bittigary. My name is Corey Swanson. Do we have your split time for your rebuttal?
Yes, sir.
Okay. Ready? You can begin, Mr. Stevens, whenever you're ready.
Thank you, Your Honor.
Good morning, Your Honors. Thank you for having me. As I said, my name is Colin Stevens. I represent the appellant in this case, Andrew Smith. There's two issues before the court, as you probably heard from the nice introduction. The first is whether the district court erred. In fact, the district court did err in precluding Mr. Smith from allowing himself to present a lesser included offense of mitigated deliberate homicide based solely under the theory that Mr. Smith was also proceeding under a justifiable use of force claim. The second argument is whether the district court violated Mr. Smith's constitutional rights and Section 4616, 503 sub 2, when the district court replied to two jury notes in kind of the middle of trial without consulting really anyone as the court did it, but only told them after the fact. The first issue is really the most dispositive. It's also the most entertaining, so I'm going to start with that. A defendant in a deliberate homicide case should not have to surrender his ability to seek a lesser included offense instruction of justifiable or of mitigated if that individual is also relying on the affirmative defense of justifiable use of force. But that's precisely what happened in Mr. Smith's case. The state argued, and the district court accepted that argument, that because justifiable use of force could, if believed by the jury, result in an acquittal, then based on some of the language in this court's previous opinions, that the lesser included offense was not appropriate. That legally tenuous proposition kind of comes from this court's decisions in German, in Martinez, and earlier cases upon which those two rely. I would note that on Wednesday, this court issued the State versus Delaney opinion in which it undercut some of the German dicta in the case that was also raised on below in Mr. Smith's case. And I'll get to Delaney in a bit. But as we trace kind of the progression of the German and the Martinez broad holding, right? This holding that you can't seek a lesser included if you're relying on basically an affirmative defense that would result in acquittal. As you drill down into that case law, you find that it doesn't really exist, that the earlier cases that German and Martinez relied upon don't actually stand for that proposition. And in fact, if we go back further, before the Model Penal Code and before the 1973 changes in the Montana criminal law, you also find support for the fact that a defendant can adopt alternative theories and essentially say, well, yes, I shot him in self-defense, but if you don't believe that, convict me of the lesser included. And so mitigated, if you go to the commentators in the annotations, mitigated replaced voluntary manslaughter in our criminal code, but it continued coverage kind of that lesser included offense. So going back to, I think as early as 1900 through 1970, there's case law that supports the proposition that self-defense claim also supports a finding of voluntary manslaughter as a lesser included. 1901, State versus Shadwell from this court. 1966, State versus Thomas. 1970, State versus Logan.
So,
Go ahead.
assuming that we get past the legal problem, I'll call it that, of presenting alternative theories, the evidence in this case, I guess, can you address, first of all, are we looking at a motion in limine denial, or the grant by the district court, or the jury instructions, or both? And then does the evidence, because you're not entitled to a jury instruction unless the evidence supports the jury instruction. So how does the evidence here support a jury instruction on mitigated?
Sure, Justice McKinnon, so I'll break that down. I think the root problem in this case came from the district court's grant of the pretrial motion in limine. And so from that decision is the basic preclusion of Mr. Smith's ability to then present evidence that would ultimately support the lesser included instruction.
So if the district court did an error in its granting of the state's motion in limine on any of the mental disease or disorder evidence, then is that dispositive? I mean, if we find that that was not an error, was there any evidence independent of that evidence that was excluded that would support an instruction for mitigated deliberate homicide?
Yes.
What was it?
No, so it's that was excluded?
No, the evidence, if we were to affirm the district court and say that it did not err in excluding the mental disease or disorder evidence that you wanted to introduce, or that counsel wanted to introduce at trial, if that was not an error, then was there still evidence that was presented at trial that would have supported a mitigated deliberate homicide instruction?
Yes, I believe so.
And what was it?
Yeah, so there was a lot of discussion, and in fact, I think arguably the state opened the door to the issue again, because there were multiple questions posed by the prosecutor to its own witnesses about what was Mr. Smith's demeanor, how was he acting. I think first responder witnesses indicate he was pacing back and forth. I believe Mr. Sandman described him as elevated.
But this is all after the shooting.
Correct.
And stabbing.
Correct.
Right.
So,
well, anyone would be agitated at that point.
yes, I would agree with that, Mr. Chief Justice. So those are kind of the after-the-fact witnesses. Mr. Smith himself then began to testify about, whether and when he saw the gun. I think that evidence was disputed, but if we look at the court's requirements on what gets you to a lesser included offense instruction, there's no real high watermark of at what point you tip over. So I think if you have this case, right, and you have Mr. Smith who testified he was out there, he may have asked Mr. Patterson for a light. Mr. Patterson was rude to him, maybe said some offensive things about Mr. Smith's fiance, and then it's kind of on, right? There's a gun, there's the bear hug that's discussed in Mr. Smith's testimony. So in answer to your question, Justice Shea, I think that gets you to the mitigated, to the maybe if my use of force was excessive, I still have this, reasonable, heightened emotional situation that gets me to the lesser included.
I'm concerned that the argument you're asking us to agree with blurs that line between whatever caused the person to believe they had to use force, and also using that same evidence as the mitigation belief that he had, I guess, some kind of stress going on. Like pages 23 and 24 of your brief really culminate this. It appears to me what you're saying is, if I perceived that there was a threat from another person that justified me using force, that same threat also gives me the mitigated evidence that there was the stress or the duress or emotional whatever going on to get mitigated. It looks to me like that's the argument you're making. If that's the case, every time there's any altercation, there would automatically be mitigated regardless of the evidence at trial.
Yeah, Mr. Chief Justice, I think what we're dealing with specifically here is a deliberate homicide, right? So,
Well, I'm talking specifically about mitigated
Okay.
in deliberate homicide,
Yeah.
not other crimes.
okay, so I agree with that 100%. And I think, you get to this issue of, is a defendant allowed to essentially present not an alternative theory, but to basically hedge his bets and say, here is the situation that caused me to use force. Now, whether that situation warranted lethal force is a question for the jury to decide, right?
Okay.
And then if the jury then says, well, no, you were entitled to use force, but not lethal force, then I think it transitions into mitigated, that you're able to sort of use those two things.
So the question is, how is mitigated deliberate homicide different from other lesser included offenses? Other lesser included offenses, generally, you take away an element from the greater crime to get to the lesser. In mitigated, I'm looking at our decision in De Montana and Scarborough, so 2002 and 2000.
Mm-hmm.
Both of them say, to get to mitigated, you have all the elements of deliberate homicide, plus you add the stress or the duress. So I'm wondering if our rule from Avadia and everybody below that, German, whether that it should be different for mitigated deliberate homicide as opposed to other lesser included offenses. This is a very roundabout way of trying to agree with you, but I'm struggling to get the words out.
No, and I appreciate that, Your Honor, and I'm maybe not tracking the question, but if I'm understanding correctly, how does mitigated differ from other lesser included offenses? And I think you're absolutely right that mitigated's weird, right? It's just this kind of non-element, non-burden that either side potentially gets to throw out there. So it is different in that sense from other affirmative defenses. I mean, I don't know if that answers your question, Your Honor, but it's just different. I mean, the statute it's a different breed of cat.
That's why we're here, trying to figure it out.
Mr.
So
Stevens,
counsel, I'm sorry, go ahead.
I just want to follow or circle back to your statement. First, that you said the ruling on the motion in limine was the root of the problem. But then in response to some of the questions, it sounds like you're arguing that even if the mental disease or defect evidence was excluded, your client still should have gotten a mitigated instruction. So I want to make sure I understand what you're arguing on appeal in terms of the relationship between the lesser offense instruction and the exclusion of this mental disease evidence.
So, Justice Baker, setting aside my opinion on the pretrial ruling, I think Mr. Smith's trial counsel did what he could to claw in mitigating evidence. And I just think that came through in simply the facts of the case in terms of Mr. Smith's own testimony. And stop me, Justice Baker, if I'm not answering your question, but the reality is, but for the pretrial ruling, there could have been a lot more.
Okay, so let's talk about that pretrial ruling, right? I mean, so you wanted to present delusions of some kind?
Correct.
And were you wanting to present, like, I don't know, did you make the offer of proof? Was it history of delusions? Or are you asserting that you could have, or trial counsel could have produced evidence that at the time of the event, he was suffering delusions.
Well, so
which is kind of different, right?
Yeah, so I don't want to blur, and I think this kind of became the problem below. I don't want to blur the mental disease sort of, or disorder or defect issue, which stands alone. And I think that kind of gave rise to some of this pretrial ruling problem where the state was arguing that the defendant's trying to bootstrap MDD into an actual trial defense.
Which his lawyer agreed with.
Yes, I don't.
And you don't think we shouldn't do that?
Well, I think you can do it with it because of the unique nature of mitigated. And I don't want to get away from your original question. But because mental disease or defect, right, let me go back to your original question. Because Mr. Smith was committed, there was a report in the record, it appears several times in the record, about his mental issues. I think there's an individual who, after he was caught sneaking naked onto Malmstrom Air Force Base, who diagnosed him with PTSD and with kind of this delusional disorder. He gets committed. There's a DPHHS report from, I believe it's Dr. Kurtz, that has all of this information. That's in the record before the court, and that's what, obviously, in a perfect world, he would be able to present to the court as part of it.
But
Which wasn't necessarily helpful to him.
Yeah, I was like, if he can present that, how is it helpful to it? Like, was he suffering delusions at the time of the incident? Or, I mean, there are people who do suffer delusions, right? But not all the time.
Correct.
And so the fact that you suffered some delusions here, but didn't during the incident, right? How is that helpful to him?
Well, I don't want to cabin it just to delusions, because I think there is evidence of PTSD too.
Okay.
So you get to, that becomes the lens that mitigated is then viewed through. And maybe it's not delusions versus as it's, I have PTSD, I'm a battered spouse, I'm a soldier, and I perceive a situation which then causes me to elevate, to use Mr. Sandman's language. And maybe it becomes excessive, but I guess it's my reasonable belief, mitigated, right, that I then get to use that level of force.
But the reasonable belief by the statute has to be from the viewpoint of a reasonable person in the actor's situation. The situation in this case being the confrontation between himself and Mr. Patterson with the gun and the knife. The problem is that I'm having a difficult time reconciling is the mental disease or disorder, by its very nature, is saying that you have a mental state that is compromised such that you can't form the requisite mental state for that element of the crime. So by definition, you're not acting from the viewpoint of a reasonable person. And so I have a tough time seeing how you can, and this kind of goes back to what the state's argument was before. I mean, they kind of simplified it to external forces versus internal. But I mean, that there's some, I see where that's coming from, because you're talking about you're not acting from the viewpoint of a reasonable person if you are operating under the influence of an organic mental disease or disorder, are you?
If it's organic, I think that's a great argument, Justice Shea. I mean, if it is some sort of organic.
Well, even if it's anything that qualifies under the statute as a mental disease or disorder.
Right.
If you're acting under the influence of a mental disease or disorder, it seems to me by that very nature and by statutory definition, you are not, your mental state has been compromised. That's the whole point, such that it negates the mental state element of the crime. For mitigated deliberate homicide, you have the mental state, but you're acting under an impulse or under the influence that a reasonable person who has all their faculties, who does not have a compromised mental state, would have the impulse to commit the crime that they committed.
Yeah, I don't think it goes that far, though. I mean, ultimately, it should be up to the jury to say this was reasonable or not. So I think the example that was used in the opening was, well, someone shoots my dog, right? And then I then shoot them. And my dog's worthless, Justice Shea. I mean, if someone shot
Feel
my
bad for your dog.
they would have my undying gratitude. So whether that's reasonable or not,
You have a lot of dog lovers up here, just letting you know.
Yeah.
I mean,
I love him, but my goodness. So whether that's reasonable should be entirely up to the jury and not foreclosed pre-trial.
but
Go ahead, Chief.
Go ahead. You sure?
Yeah.
The evidence has to be admissible for the jury to decide that. How does this report get admitted? 4614-217 makes it very clear statements for mental evaluation and treatment are not admissible unless the defendant puts a mental state at issue under this chapter. And that chapter is you have a mental disease that makes you unable to form the requisite mental state, or you have a mental disease which makes you unable to appreciate and conform. This isn't happening in this trial. So my concern is this is a side door that's going to kind of just blow a hole in the mental defense scheme, because this could be presented at sentencing for mitigation, but I don't know how it gets into trial.
Sure. So let me first, keeping your question firmly in mind, Chief Justice Swanson, I'm not sure the court needs to get to that decision today to resolve this, because ideally the case would be remanded and Mr. Smith would then be given the opportunity to address some of these evidentiary issues. And
Wouldn't we have to rule that in order to say that the motion in limine order was wrong?
No, I don't think so.
Why?
Because I think the court can say, based on the premise of the holding, right? You've got this broad holding that essentially puts justifiable use of force and the lesser included offense completely at odds together. I think this court can say, well, that's just wrong. They can be reconciled. Good luck, Mr. Smith, at a retrial, trying to convince the district court that you're eligible for this lesser included offense. So, but with that said, I think arguing that the report itself comes in would be obviously a bridge too far for me. But
Well, counsel, you want the evidence in from the counselors too, right? That's what, because trial counsel dropped the MDD defense.
correct, yes.
And they did not want, and that was after they got the report. They did not want the report in. I don't see the report as helping a mitigation defense. So my question is, you've got how are the counselors' testimony going to help on the mitigation defense? And was there a proffer on that in the trial court? And then secondly, the state, would they not be able to use the report to rebut the testimony that Smith put on through the counselors, which, in my opinion, is very damning of a mitigation defense? And I'm not going to disclose the contents of the report, obviously, but.
Yeah, so Justice McKinnon, I'll go in reverse order. The answer to your second question is yes, the state, I believe, could rebut it. And that would be a strategic decision that Mr. Smith and his counsel would have to make at a new trial. Because, I mean, that's just what happens at trial, right? With door opening and 404B, and is that necessarily something you want to do? How would the counselor's testimony have helped? If you have, and I think it's clear that Mr. Smith has an obligation to testify if he's going to raise justifiable use of force. And so assuming that he gives the same testimony that he did in his first trial with additional evidence about, his own problems, not maybe necessarily to a diagnostic level, but to his own personal beliefs and his own personal impressions of his perception of what Mr. Patterson was doing, then I think it could be helpful. It could supplement, and I'm not just going to say bolster, but it could aid the jury's consideration of the reasonableness of Mr. Smith's belief. There was no proffer.
Okay, so that's not in the record?
Correct.
Okay.
I guess what is not in the record?
The counselors, what the counselors would have testified to?
No, it is not.
And there also was no proffer from him about what else he would have testified to besides what he did testify to about Patterson's behavior and statements.
No proffer from Mr. Smith.
Right.
Correct.
How much time do you have left? Because I want to ask you about the jury as well.
17 minutes.
I mean, are you saving time for rebuttal?
7 minutes.
Okay. So go ahead. I'm going to interrupt you in a few minutes and ask you about the jury.
About the jury questions?
Yeah.
Well, let's transition to the jury questions
Okay.
then.
So here's my question. The statute addressing how the court handles jury instructions is specifically dealing with deliberation.
Correct.
So this is during trial still, pre-deliberation. My impression is the judge handled it correctly, because if he brings everybody in and talks about it, the counsel then can respond during trial. The jury figures, and it kind of produces this dialogue between the jurors and the counsel during trial if they're asking questions and then counsel's responding. So how do we foreclose that? I think the judge handled it correctly. Tell me why I'm wrong.
Because he didn't put it on the record. So
Well, I've read the questions. They're in the record.
the questions are in the record, but the judge's response to those questions is not in the record.
His saying, I told him I can't answer that question, isn't sufficient?
And then what would be ideal is what we normally do at deliberations is then the judge writes the question. My problem with the case is that, this is a small county. I've been to win it for the minute. My wife's cousin was on the jury. That's how small it is. So the bailiff goes back and says, I don't know what the bailiff says. So I think what the district court judge did that was erroneous was you get the question, you confer with the parties, ideally with Mr. Smith present, and you say, here is how I'm going to answer this question. It's an evidentiary issue. Ladies and gentlemen, you'll maybe hear about it, maybe you won't. That note goes in the record, and it's given to the jury.
How do you show plain error?
You get to the error through the deliberation statute that the Chief Justice just referenced, and it escapes me right now,
we've got
Justice 46-16-502. Because it deals with deliberations, it's slightly different, but the underlying principle, and the constitutional principles that are referenced in, I think, the 10th Circuit cases and some of the other cases in the brief, it undermines the constitutionality of and the integrity of the system, because I think it seems pretty clear to me, and this is just me speculating because we don't have an appropriate record, is the jurors are chatting about this. And if they're not chatting about it, again, you have a bailiff who goes back and maybe opens the door to the deliberation room and says, folks, I get your question, and here's what the judge said.
But what the judge said was that he couldn't answer their question. And, at least that's what he told the bailiff to tell the jury.
That is correct.
But, one of the other kind of predicates for that is not just that it is after the jury has retired for deliberation, but it's also in terms of consulting with the parties. It's before giving an answer. It says the information requested may be given in the discretion of the court after consultation with the parties. Your objection here is that he didn't consult the parties before responding, but he didn't give them the information. He said, I can't give you the information.
Yes, and I see no legal basis for that.
Exactly. I do not
Decision.
agree that it's improper for there to be a dialogue. When I handled jury trials and I had questions, I would share the question with counsel so that precisely they could go forward and address the juror's question. So, that's where I'm starting from. And I guess back to Justice Baker's question about plain error. How does that factor into the plain error analysis? That the judge did not give that question to counsel so that they could better proceed with answering, providing the evidence that was needed.
Justice McKinnon, I'm not sure that not giving it to counsel warrants plain error. There's this discussion about whether jurors are allowed to ask questions. And, the Seventh Circuit did a great jury study, I want to say in 2017, about whether jurors should ask questions. So I don't think that gets to plain error. What I think the issue then becomes is we don't know. And again, when it's a small town and it seems like everybody knew the bailiff, and did the jurors then ask the bailiff questions? And he's trying to be helpful to his friends and neighbors. There's just too much uncertainty, but I do have, as a trial lawyer myself, have a legitimate problem with a district court judge who said, well, this is an evidentiary issue and I'm not going to tell you what it is because I want to answer that.
When the jury goes out for a recess, they're instructed usually not to discuss the case. So what you're saying is that they did discuss the case, obviously, because of the questions that were made. And the questions are assigned by one juror alone. How do you know, are we supposed to assume that there was discussion about that question? And does that warrant plain error?
Well, I think, I would say yes. I think that gets to the point of it undermines the integrity of this proceeding because, again, we don't know whether the bailiff went back and called that one juror aside and said, here's what the judge said, or whether he told the entire room, which then...
But that kind of gets back to the plain error question, and I guess I want to be clear about what the record is. At least with the first question, it's my understanding that the judge disclosed to the counsel that there had been a question before the case wrapped up. So the trial was still going on, at least on the first question.
Correct.
And what about the second?
I think same thing.
Okay, so at that point, the defendant could have said, whoa, let's get the bailiff here and find out what happened. And then we'd have a record and we'd be able to see if the speculation that you're making was substantiated. And without that, we have to speculate and assume that the defendant's rights were prejudicially affected. That's the concern I have, is that's why we require objections to be made at the trial level.
And I think the problem with this specific issue, Justice Baker, is that I don't see a way to resolve this question unless the court invokes plain error. If you kick it back to post-conviction relief, and Mr. Smith is on his own to try to raise this issue, you also run into the evidentiary preclusion, right, that a juror doesn't get to be called in and questioned about their verdict. Now, I think that, there's the U.S. Supreme Court case out of Colorado about whether extraneous evidence came in and whether, one juror was testifying about unconstitutionally elevated issues, race, bias, things like that. But I don't see a way for this court to remedy this without invoking plain error and addressing it here on direct appeal.
Well, but you're asking us to look at this on a plain error basis. You're not raising ineffective assistance of trial counsel, which would be the issue raised on post-conviction. But to Justice Baker's point, wasn't there, the first question was asked, I believe it was on the morning of the second day of trial, when yes, it was still going on. And then the last one was asked after, I believe it was before closings at least. It was after the state's rebuttal and before closing. So trial's still going on. So wasn't it incumbent upon trial counsel to say, because one of the other things that I find more troubling in terms of the response than the fact that the answer to the question precisely wasn't on the record is your point that you raised about the jury's asking questions during trial, which seems to me to raise a separate issue that isn't, you kind of have that as part of the larger issue. But so what was it, wasn't counsel, or shouldn't counsel, defense counsel at trial have, as Justice Baker said, made some sort of an objection and asked for the jury to be instructed, as they had been before, or admonished, you're not asking questions at this point?
Yeah, absolutely. I think that was incumbent on defense counsel. I think it was incumbent on the state, and I definitely think it was incumbent on the district court, who reads that instruction every single break. They get up to go potty, right, and ladies and gentlemen, before you go, hold on a second.
Yeah.
Right? So,
but where's the evidence that they were actually deliberating? So I looked at all three. The questions are by two different people, neither of which is the foreman. Looked at that. So it looks to me like individual questions. the prohibition doesn't say you can't think about the case or think about what a witness just testified about. So for us to get to plain error, we have to insert some kind of evidence that they were deliberating, don't we?
No, I don't think, I mean, deliberating to me has a specific legal connotation, right? The jury's then off to deliberate as a collective group. The law is pretty clear that the jurors don't get to, sort of form ad hoc little groups.
Right, but where's the evidence that that happened? These are individual questions by 3 different individuals.
Yeah, so Chief Justice Swanson, the best I can give you is the fact that the notes exist in the first place.
Okay.
If there's no other questions, I'd reserve the remainder of my time.
Thank you.
Thank you.
May it please the court. Good morning. Roy Brown, Assistant Attorney General for the Department of Justice. The state believes that this court will want to hear about 3 main issues. The first issue is whether this court abused its discretion in holding that the defense may not bootstrap mental disease or defect evidence toward a mitigated deliberate homicide theory. And the second issue, notwithstanding that Smith concedes in his reply brief that the scope of his issues is limited to the limine order, the second issue that the state thinks that this court wants to hear about is whether at the close of the evidence, the district court erred in denying the mitigated deliberate homicide instruction. And the third issue, of course, we're under plain error here, as defense counsel concedes, is whether the district court erred in its resolution of the 2 notes that occurred mid-trial from individual jurors. So, under the first issue, the limine order, the district court did not err in ruling MDD evidence could not be used to support a mitigated theory. Now, these are fundamentally different inquiries. As this court has already explained, one is going towards purpose and knowledge for absence of mental state, and the other says, or mitigated says, I did it, I acted purposely and knowingly, but I was under an extreme mental or emotional stress at the time. And it should be not, it can't be disputed that that's exactly what defense counsel wanted to do here. They say in DACA 100, we want to use this evaluation in support of mitigated, and then they say at the limine hearing, we do want to bootstrap some of that from the mental disease or defect evaluation, which again, only goes towards purposely and knowingly.
Mr. Brown, let me ask you, are you conceding that it's okay to pursue both a mitigated deliberate homicide lesser and a justifiable use of force at the same time? And
well, Your Honor, I have a very long-winded answer to that question.
we are ready.
Just consider it double, because I was about to ask the same thing.
Well, so with this acquittal principle, there's 2 ways of looking at it. You're looking at the defendant's theory or you're looking at the defendant's evidence, okay? And so we have German and Martinez, where it seems like they're saying like black letter law, acquittal on the greater offense, you can't get the lesser included offense. And then we have some sort of maybe limiting going back from Freiberg and Daniels, but they don't overrule these cases of German and Martinez. But then we have to ultimately look at Kraft, which was decided after the district court's resolution of this case. And the Kraft decision seems to say, well, we're not talking about the greater, the lesser included, we're talking about the greater and lesser included going towards acquittal. And in Kraft, it was kind of an easy answer there, right? Because like the defense was never going to get mitigated in the first place because their theory was acquittal. It was that I wasn't there, I didn't do it. So we're looking at the defendant's theory in Kraft. But in this case, we're looking at the evidence, right? And so if there was, when we're talking about the limine order, Your Honor, this is something that we're probably supposed to be looking at the close of the evidence. But then we need to look at, it's incorporating the Castle test too, because really what all these cases are getting at, and this is why this court probably shouldn't overrule Martinez and German, is because it's incorporating the Castle test at the end. We're looking, does the evidence support the theory of the lesser included instruction? And all these cases discuss that.
But that's not inconsistent with allowing alternative theories to go forward.
Yes, and it may not be inconsistent at the limine stage, Your Honor. But then we have to look at what is the potential harm from the district court's resolution at the limine order, which could be viewed as maybe a prohibition from even going towards mitigated. Well, as defense counsel conceded just now, the defense still pursued mitigated. They still did that at trial. The defense counsel was allowed to elicit without objection from the state and without intervention from the court, going towards his extreme questions, going towards his mental state. And then at the close of the evidence, the defense asked for mitigated. So to the extent that the defense could have thought,
But wouldn't the district court's ruling on the motion in limine that precluded evidence of mental disease or defect prevent the defense from introducing expert testimony that would have shed light on PTSD and the influence that might have had on the defendant's actions, instead of just limiting the defendant himself to speaking to the issue?
well, Your Honor, I first want to address that, I think that what your question, what the heart of it gets to, is whether there is evidence that the defense could have presented that maybe did not rise to the level of mental disease or defect, but they wanted to get it in there. And I think, in this circumstance, the defense was not precluded from doing so. What they were very clear about was that they wanted to bootstrap the purposely or knowingly from the evaluation. And so when we're getting to the evaluation comes out, they could have rejoined that issue at that time and said, well, wait, maybe there's something in here that goes to his extreme mental or emotional stress. But the defense didn't do that. In fact, they abandoned what experts they had at that point. And I hope that answers your question.
Well, did they abandon the experts because of the limine ruling, or is it clear?
Well, see, we can just go back to the procedural history of this case. So they notice up Karanen and Decker, who are the other people that they want to talk about historical, presumably maybe his historical delusions, which wouldn't even go contemporaneous to the homicide. But so they notice those people up. By the time the limine order comes out, and I believe that's March 28th, 2022, by the way, Smith had already dropped Dr. Smelko at this point long ago because he asked not to write up the results from that report. But by the time the order comes out on March 28th, 2022, Smith takes no action with these experts. And then once the evaluation comes out, it becomes pretty clear at that point, when you're looking at, maybe Karanen compared to the Montana State Hospital experts who just opined that, Smith's delusions did not impact him at the time of the offense, that's when they 3 days later, they abandoned the witnesses that they considered possibly presenting. And so
that's the challenge, because if you do justifiable use of force, you concede you acted purposely and knowingly.
yeah.
So back to Justice McKinnon's question. Can you do that, but also argue mitigation in the event the jury doesn't acquit you? Because if you look at the Castle test and all those things, we're generally looking at, that's my issue. Is mitigated deliberate homicide a different, lesser included offense than others because it requires you to first find guilt of the higher offense and then look at the lower? Or all the other ones, if you find not guilty on the higher offense, then you look at the lower? Help me out with that.
Yeah, and I appreciate the question, and I understand that mitigated is statutorily a lesser included offense, but it's or according to case law, an affirmative defense, and I think it's not necessarily inconsistent with JUOF in the circumstance, but we don't know that at the limiting stage, right? So I think that's more a question appropriate at the close of the evidence. But ultimately, with this case, at the close of the evidence, it becomes an easy answer. The mitigated instruction was not appropriate because Smith did not present any evidence of mitigation. I want to go to some cases, some persuasive authority as to saying that mental disease or defect is not insanity. And Justice Shea, your point was right on there about the objective versus the subjective sphere, right? So you have the subjective, extreme mental or emotional stress, but you have the objective, reasonable person in the act or situation. I want to point to State v. Counts, 311 or 616, a 1991 case from Oregon. So their legislature, okay, let me back up a little bit. Model Penal Code is what Montana statute is adapted from. The Model Penal Code says, the reasonableness of such explanation or excuse shall be determined from the viewpoint of a person in the act or situation under the circumstances the actor believes them to be. But Montana says, the reasonableness of the explanation or excuse must be determined from the viewpoint of a reasonable person in the act or situation. So Oregon had the same thing. The legislature replaced a person with an ordinary person. And the Oregon Supreme Court said evidence of insanity not to be taken into account for manslaughter because the legislature adopted more objective language to counterbalance the subjective element. So counterbalance that extreme mental or emotional stress. And the Oregon Supreme Court even asked the question, what circumstance, for example, would not be reasonable as viewed from the standpoint of an ordinary insane person? So that gets back to your point, Justice Shea, that it's going to be very difficult for the jury to overlay a delusion on top in a mitigated theory on top of a circumstance for an emotional stress.
Counsel, what was the cite on counts again?
Oh, sorry, I'm talking very quickly. 311 or 616, the state is State vs. Counts, COUNTS, 1991 case. And we can also look at State vs. Dumblau. Now, Montana's statute is one of a few statutes that say extreme mental or emotional stress. Some just say emotional disturbance. But another statute, Hawaii's is substantially similar to Montana's. In State vs. Dumblau, 715P2D822DUMLAO is the case. They say extreme mental or emotional disturbance sometimes is, but should not be confused with the insanity defense. The point of an extreme emotional disturbance defense is to provide a basis for mitigation that differs from a finding of mental disease or defect, precluding criminal responsibility. So I think it's very clear at this point that the district court did not err by saying that the defense may not bootstrap mental disease or defect evidence in support of mitigated.
How do you separate the two?
Mental disease and mitigated?
Yeah, I mean, how do you, mitigated, you're looking at the person's, disposition at the time of the offense, which is going to overlap with issues of mental disease and defect.
Well, I think the cleanest...
How are we supposed to help trial courts going forward distinguish between, the two?
Oh, okay. So you're saying, okay, let me see if I understand this. So you're saying, like, if there's something that doesn't rise to the level of mental disease or defect,
like here,
going towards purposely or knowingly, how do we distinguish that for everyone? Well, I think, there could...
but you still have, you want them to be able to present their defense, which might include psychological histories or psychological background, because a mitigated is involves where that person was in terms of their brain.
Yeah, and I think the cleanest way to distinguish it is what the state has already explained, that mental disease or defect defense goes towards purposely and knowingly. So that portion, let's just look at the evaluation, for example. That portion of the evaluation that went towards purposely and knowingly, when it said, oh, he did act purposely and knowingly, because that was the question that was put towards us from the evaluation itself, he can't bring that in. But let's say there was something in the evaluation that went towards an emotional disturbance that didn't rise to that level, and maybe there was something in there that didn't relate to that. But yeah, it's a difficult question, Your Honor. But I think as long as we have that dividing line between purpose and knowledge, and it also depends on how the defense really, failed to have an offer of proof here. So I think, the defense wasn't fully formed as to their theory, but it was fully formed as to what they wanted to do. They wanted to use that mental disease or defect evidence without really a proffer of what it went toward. So I think that's a difficulty in this case.
But in that answer, we're back to the admissibility problem of these statements come in when they were doing a psychiatric evaluation at Galen, and now the defense wants to offer them. But there's all kinds of problems with that. I mean, you're there for 60 days. They say you're there for Miranda, but the person knows they have to cooperate or they're not leaving. And then the defense wants to offer that, and the state's in a weird position as to how they rebut it or follow up. It just seems messy. Why don't we just stick with the clear line from 4614? If it's evidence obtained through the evaluation, it's only brought in if the defendant offers it for mental state defense under that chapter.
Yeah, and I agree with you, Honor, but I think it's important to point out here what the state was doing here and what the district court, they were very careful. They weren't trying to preclude Smith from pursuing any affirmative defenses he wanted to do. So if it came out at the time that first, the state initially asked for the fitness evaluation, okay, and then the defense comes back and asks for the rest of the evaluation. And this is way before even the limine order.
That's a good point.
So at that time when the defense asked for the fitness evaluation, he could have said, we want to look into this extreme mental or emotional stress. We want to put this question to the evaluators. Smith did not do that. And then the evaluation comes out, and not only do they not rely on that, but they abandon their witnesses. So I think the procedural history of this case is very difficult because it was made difficult by the defense. They weren't being forthcoming about whether they were even pursuing a mental disease or defect defense. They didn't notice up any experts. They didn't provide expert reports. They just attached some treatment notes and said, we want to pursue this and we want to use it from mental disease or defect evidence. That's not permissible under Montana law, and no jurisdiction in the country has found that that is permissible.
So
we
you,
still have,
no, go ahead.
we still have the counselors that they were precluded from using. The two counselors that were, within a month of the incident that he was seeing?
Yes, so I disagree with you there, Your Honor. The district court did not preclude the counselors from doing anything. What the district court did in the order was say, no, you can't present mental disease or defect in support of mitigate it. And they were all talking about the valuation at that point.
Okay.
So I do want to get to this jury issue and ask if there's any questions regarding that. But
Counsel, before you do, let me ask one more question about
Yes.
what you've already argued. Is there a harmless error analysis here that is appropriate? I mean, even Mr. Stevens' argument, he indicates that we could hold in his client's favor, remand, and tell his client, good luck getting this to work for you.
Right.
The evidence is very strong against the defendant. The jury obviously was not believing that he had acted reasonably and justifiably in the decision to use force. So
Yeah.
does harmless error enter into this?
Okay, so let me address that first by talking about the limine stage, and then I'll talk about at the close of the evidence to the court to the extent this court wants to hear about it. So the limine stage, the resolution of this case is very simple. As we said, defense counsel has conceded in his reply brief, he's only challenging the limine stage, so we don't even need to get to the trial. But there's two aspects of the district court's decision in the limine stage. The first aspect, mental disease or defect evidence should not be bootstrapped towards mitigated, and that's absolutely correct. The second aspect, JUF acquittal principle. Now, we've identified that the risk would be potentially they could not pursue mitigated, but they did pursue mitigated. So that's the state's answer towards the limine stage. There's a clear path to affirmance here. But if we're looking at the close of the evidence too, there was no evidence in mitigation presented at all. And sorry, I wanted to I wanted to fully address your harmless error question first. If we look at the evidence at trial, we're looking at whether a jury could rationally find they were entitled to the lesser included instruction. Here, there's no way the jury could rationally find that. The evidence showed that the blood was inside of Smith's pants, indicating that he was going for the gun by the time he was stabbed. And of course, I'm sorry, I might have said Smith, I meant Larry. Right. But Larry was also already on the ground at that time because the blood had not saturated downward up towards the front of his pants, and then his shoes had no blood on it either. And then Smith's whole story that there was the shot first, and then he was maybe 4 feet away and closed the distance is impossibility because...
I think we can concede that Mr. Smith's story was not very credible at trial. So.
Okay, so let's talk about Smith's theory.
Well, I want to go back to the part about the motion in limine and the two parts that you say applied at that stage of the proceedings. You say that the ruling of the district court was that the mental disease and defect should not be bootstrapped to mitigation.
Yeah.
What kind of a tightrope would a defendant have to walk to honor the district court's ruling that you can't present mental disease or defect in your endeavor to show mitigation and show mitigation?
Well, I think it's a good question, right? But like, the mental disease or defect is only precluded to the extent it goes towards purposely and knowingly. So,
But you said that the limine orders said that it couldn't be used for purposes of showing mitigation.
yeah, exactly.
So what, and then at the same breath you say, and then they didn't show any. It's like, what would a defendant have to do so as to abide by the district court ruling on the motion in limine?
Well, yeah, and so it would be an emotional disturbance, something that happened contemporaneously to the event. So the defense would have to show, they would have to show the mitigation factors at that time. Was he under an extreme mental emotional stress? Was there a provocation? Could an objective, reasonable person in the defendant's shoes? And that maybe goes towards, maybe they would need an expert. Maybe they would need an expert to overlay this delusion over to the jury. But I don't think that's ultimately a question that needs to be asked here because there were no experts and the experts were abandoned at that time. And so we can overlay an acquiescence principle here.
So refresh my memory on that. Were the experts abandoned after the district court's order on the motion in limine?
No, and I think that's very telling here because the experts were abandoned 2 weeks later, 3 days after the evaluation came out. So
Wait, 2 weeks later than what?
then the limine order.
Right, so the district court said, you can't present this evidence, and then they abandoned the evidence because the district court told them they couldn't use it.
Well, they abandoned the evidence because it wouldn't have been helpful to them because like what they wanted to do was
That's
use...
speculation.
Huh?
That's speculation on your part. You don't know the reason exactly why they abandoned it, but we can agree that the motion in limine was March 28, 2022, and then 2 weeks later, they decided then they can't present their experts. But we don't know exactly the thinking that went into that decision.
Well, we can look at what Smith said, what his counsel said. We can look at... I'm sorry, I got a million papers here. On March 8, 2022, Smith counsel responded to the state's limine and said he may rely on the evaluation itself to argue mitigated deliberate homicide.
On March 8th?
Yeah, on March
And
8th.
that's before the court said, no, you can't do that.
Yeah,
And so
exactly.
when the court said you can't do that, they abandoned their experts.
Well, the court didn't say in its order that he couldn't do that. The court didn't say you can't use the evaluation at all. The court said you can't use the evaluation as it goes toward a mental disease or defect, and the scope of that is purposely and knowingly, Your Honor.
So you're not saying that a defendant could never use something that might have been in a psychiatric evaluation, could never call one of those witnesses to testify about what he was going through that could have shown extreme mental or emotional stress?
It could certainly be possible, yeah, Your Honor. I agree with you there.
You're saying it's not demonstrated in this record or by this report?
Correct.
Okay.
Yes. I'm sorry, Justin McKinnon, I interrupted you for a second. You had a question?
Well, I guess I'm back to these counselors, which came after the motion in limine, and you said, I mean, didn't the district court preclude the defense from presenting that evidence?
From the counselors?
Yeah.
No. Because like, as I said, like Smith said he wanted to rely on the valuation. It's not, this is problematic, right? Because like, it's not clear what Smith wanted to use these counselors for. He just attached a couple treatment notes from prior counseling sessions, and we don't have an expert report disclosure. We don't even have a clear theory at the point of the limine hearing as to what Smith wanted to use these counselors for. So I will agree with you there but we can. But ultimately, they were abandoned. So I guess that's the state's argument.
But that could have been something that would go to mitigation. The counselor's testimony that he was delusional, substance use, that sort of thing, it just wasn't developed?
Well, yeah, so if the counselors could have testified that he was under an extreme mental or emotional stress at the time of the homicide, they could have offered something about that.
So could they...
Go ahead.
Okay. So could they, I'm just trying to kind of piece this together here. So could they say it is something that this person may have been more predisposed because of PTSD or something like that? So they have something that would not rise to the level of a mental disease or disorder that would abrogate the mental state, But somebody, you could still have a reasonable person, kind of like the eggshell defendant, I guess, for lack of a better way to put it.
Yeah, and I mean, you know, it's possible, yeah, absolutely. I think.
You're just saying it's not here.
It's just not here, yeah.
And there's a lot of evidence of the drug use as well that seems to be exacerbating whatever his problems are.
Yes, Your Honor. And so that's another portion of, so when we're talking about the evaluation, they're talking about a substance-induced psychotic disorder from longstanding methamphetamine and marijuana use. Now, this court has said time and time again, intoxication is not sufficient for mitigation. But they're also part of that evaluation was saying, he has a long-standing history of aggressive behavior that's not impacted from delusions. He acted purposely and knowingly at the time of the offense, and there was no delusion that was fully formed towards Larry at this time. And Smith absolutely agreed with that. He said, oh, I'm doing JUF. I don't think I had a delusion. I wasn't delusional at the time of the offense. And so when you look at this sort of damning evaluation in the face of the Karanin report, maybe, where it's not even a report, they're just treatment notes. But if you compare the two, it's totally reasonable what the defense did at this point by abandoning these people and after the evaluation came out.
So I want to make sure you get to the jury issue.
Yes, Your Honor. So under this issue, and the court asked a lot of good questions about this. I think what counsel's brief really went towards was maybe a right to presence claim, right? Because like they're saying, well, we don't know what happened with the bailiff. The parties weren't there for that. Okay, fine. But that doesn't relieve them from proving plain error. In cases before State v. Rime, R-E-I-M, this court somewhat analyzed more, put the burden on the state, I would say, to show prejudice in cases regarding right to presence claims, okay? But then after Rime, it turns it around and says, no, the defense has the burden of establishing plain error here. And I think what the district court did here was ensure the fundamental fairness of the proceedings. And that's because you look at the first question, right? And the person asks, well, what about the gun? Couldn't there have been a misfire? The very next witness testified to that. So it prevented the overemphasis of any one piece of evidence from both the state and the defense at that time. So the court was really, really, really trying to protect the trial record here and to protect the arguments of the parties and to protect the sanctity of the jury. So again, the brief doesn't identify any prejudice. There's no prejudice here. And so I do want to close at this point unless there's any other questions.
Justice Rice, do you feel your question was answered? Because I know we about had 4 in a row after
I'd
that.
ask if you thought a harmless error analysis was in any way appropriate here. You didn't argue it in your brief, and in response you were saying that, you know, the state was entitled to straight out affirm. So I'm taking that as meaning that you don't think harmless error is appropriate, but.
Well, no, Your Honor. And I think, you know, when we go to the JUF acquittal principle, there's no prejudicial error here in the first place. And in the appellant's brief, they don't identify any prejudice either. So to the extent to that JUF acquittal principle could have been error, there's no prejudice because they still pursued mitigated deliberate homicide. If there's any other questions, I would submit to this court.
Thank you.
Thank you.
This has been a great discussion. Should have been the discussion that was held before the district court. But my problem with this entire case is that the district court precluded essentially the ability to present a mitigated deliberate homicide, lesser included offense because of this erroneous assumption that justifiable use of force, if believed, would result in acquittal, therefore no mitigated. I think that is the 30,000-foot legal principle that started the taint in this case. And Mr. Chief Justice, I just want to maybe tweak one thing that you posed to the state about whether an individual asserting justifiable use of force concedes they acted purposely or knowingly. And again, on Wednesday, this court decided Delaney in essentially saying you concede that you acted purposely and knowingly as to your conduct, but not that you acted purposely or knowingly as to the result. And that, in Delaney, this court sort of cleaned up some of the ambiguous law surrounding that. That same issue did arise in Mr. Smith's case as well. It was the same prosecutor in both instances. I think the question really is, let's concede that for the purposes of this argument, that there is no evidence of mitigated factors in the trial record on this case. Well, you have to go back, and I think as Justice Bidigeri was suggesting, of course there isn't. The district court said you can't do this, and it said it based on the fact that you're on the horns of this dilemma of you either argue justifiable use of force or you come in and say mitigated deliberate.
So you dispute Mr. Brown's analysis that the district court didn't preclude the mitigated evidence, that the ruling on the motion in limine went solely to the MDD defense and the report.
That the ruling on the motion in limine went strictly to the MDD?
Right.
Yes, I dispute that.
Okay.
Again, because mitigated is so strange, right? It doesn't, if you look at the mental disease or disorder, it talks about, we do this, right? Whether the defendant had at the time of the offense was committed a particular state of mind that is an essential element of the offense. If you then cross-reference to mitigated, I think it's subsection 3 that the state's not required to prove it as an element, so that kind of takes us out of MDD land, and the defendant's not obligated to present it as an affirmative defense, so that again takes us out of MDD, no insanity defense in Montana, but we are allowed, and I get it, it's a complicated discussion. Defendants have to be allowed then to split this hair or walk this tightrope and be able to say, look, I'm not saying I didn't have the mental state at the time of the offense. What I'm saying is that my mental state, viewed in light of a reasonable person in my shoes, mitigates the fact that I committed a deliberate homicide. So again, it's a split hair, but we can all think of instances where this type of evidence would be appropriate. And again, whether it is a soldier with a PTSD or a battered spouse or someone who's just heightened because of a previous reasonable trauma. So
here's the question on that. That requires the expansion beyond the event to all the extraneous evidence. The person who's the other participant in that interaction is unaware of those things, presumably. Larry is unaware of whatever happened with Mr. Smith before that day. So that issue of reasonableness of the force presented against him, and therefore the reasonableness of the force that meets that, is that analysis is a complete stranger to whatever PTSD or other things that happened vis-a-vis one of those actors. So give me your thoughts on that, because it's kind of what the state's saying in terms of, that's what they said at trial, in terms of internal versus external effects.
Yeah, and I think that's just a trial argument, Your Honor, and it's a reason to go to the jury. It's a reason that this argument should go to the jury, and Mr. Geist is free to make that argument. And, Larry didn't know. Larry he'd been told to stay away by his stepdaughter and steer clear of Mr. Smith. Larry didn't know why. He just was minding his own business, smoking his cigarette. He didn't know that. And then you let the defense put on their case to the extent legally permissible, and maybe it's I win because of justifiable use of force, or my force was excessive and I get mitigated. But that's an argument that gets to be presented to a jury and through skilled advocates, I think, and not precluded as a matter of law before trial.
But does there still have to be, for the mitigated, the influence of the extreme mental or emotional stress? Does that have to be something that is a precipitating event at the time, in addition to what you're talking about as a pre-existing mental disorder that may not rise to the level of negating a mental state? But is that alone sufficient to be, so there's no nothing that you're acting under the influence of at the time of the event. It's just something that you're somebody with PTSD or something like that doesn't rise to the level? Or does there have to be something that precipitates that event?
Well, I think in this case there was something that precipitated the event. I'll quickly answer that question superficially to say, yes, there should be something to precipitate the event.
Keep going.
Thank you, Judge. But to then say, ladies and gentlemen of the jury, that's your call. Was it reasonable for me to say that precipitating event and everything I've gone through in the past is reasonable to explain this action?
Okay.
Thank you, Your Honors.
Thank you. Thank you, counsel. The case is submitted.